Hello everyone, welcome at Betweenity's webinar on the new EACCA's new merger regime and other priorities. It is great to have you with us. We are being joined by guests across many African countries and 4 continents, which indicates that this is an important event that is taking place on the 1st of November. In particular, welcome to Stellah and Denis and Vincent, our colleagues from the EACCA. They are based in Arusha in Tanzania. I will introduce them in a moment. At Betweenity, we've been tracking a lot of the developments of the EACCA since our commencement on the 1st of April 2020. And yesterday I quickly had a look and I saw that we reported on the EACCA's progress and programs in the past 4 or 5 years, 72 times. And these developments pertain to legislative developments, especially the amendments to the EAC Competition Act and the EAC Treaty. Not only the substantive changes, but also processes and progress and issues in relation to those processes. We looked at budget allocations to the EACCA, new commissioners and staff at the EACCA, investigation of anti-competitive conduct, the development of draft and final strategic plans, guidelines of forms, thresholds and filing fees, cooperation agreements between the EACCA on the one hand and competition authorities like the Kenya Authority, Tanzania and COMESA on the other hand, and input by the EAC's Business Council in relation to some of the activities of the EACCA. And very interestingly, about 2 months ago, Betweenity had a 3-day virtual conference on African competition regulation. And one of our guests were Ms. Lillian Mukuronia. And Ms. Lillian is the former registrar of the EACCA. And she shared with us some of the challenges that the EACCA faced during the first 8 to 9 years. And they were significant. And I thought it's quite important for us to understand the context and the long road that this institution has come to get us here today. And also to celebrate this moment, because it's been a long road. And thanks to the staff of the EACCA, we are here, and all of those challenges have been overcome. So some of those challenges included that at the time, 2016, both the EAC Treaty and the EAC Competition Act had significant gaps. And at that point, the policy organs were not too enthusiastic in ensuring that a law works, and they did not really see the urgency in establishing a fully functional institution. And quite interestingly, the law also granted the council with the powers to analyze a merger, especially mergers with public interest aspects or mergers on appeal. So the law had to be amended to make it more consumer friendly and also to remove that political element in the interest of credibility. The law, and this was quite a significant issue, did not give the EACCA legal personality nor independence. And the implication of that is that if the EACCA had to sign off on a document, it had to go through the Secretary General of the EAC. So you would be dependent on the board of the EAC, and you could not merely act on your own. And of course, although the EACCA strategic plans prioritized the commencement of merger regimes, the above challenges made it quite difficult for this process to even start. Also, the partner states' own interests were quite paramount, and the fears of losing jurisdiction was a real one, and that also caused a lot of delay in reaching consensus on the amendments to the Act. Ms. Mukuronia referred to the process that went through the Legislative Assembly for approval twice. And after it had been approved, one of the partner states still brought issues, and then the process had to start from scratch before the EAC's Legislative Assembly. Inadequate funding was an issue. And quite interestingly, back in 2016 or 17, there actually was enough funds for the start of the recruitment of staff and the launching of certain activities, but unfortunately that dovetailed with funding issues within the EAC, the community, as an economic bloc in itself, and they not having enough funds. And that led to a moratorium on the appointment of new employees at the EAC, with the EACCA, as well as other organs of the EAC. And because the EACCA did not have legal personality, they were dependent on the community also in that regard. Efforts to arrange for secondments from the more mature competition authorities were also unsuccessful because the EAC did not have a policy making provision for secondments. Regarding the technical capacity, it was quite interesting to note that the technical requirements that were assigned to these particular job descriptions were significant. They actually required 15 years of experience in competition law and policy from the officials that were to join the EAC. And back in 2016, that type of experience was just not available in the economic bloc. Thanks to the efforts of Ms. Lillian, they finally managed to get that 15 years down to 8 years, which made a huge difference already. But today, we have an amended EAC Competition Act, which was passed in November of last year. The EACCA now has a corporate identity and legal personality and a proper legal and institutional framework. And Stellah will tell us more about that in a while. It contains a lot of amendments to the previous version of the Act, and Denis will take us through that. And the EACCA's merger regime is ready to roll from the 1st of November onwards. And Vincent will tell us more about that. Some of the advice that Ms. Lillian offered in relation to new authorities, and I thought of just making this part of the discussion for purposes of perhaps the Q&A. The intentional development right from the start of an operationalization strategy, she suggested. She said, put in place interim measures such as a transitional task force to assist with the delivery of all sorts of infrastructures. They can have a checklist from which they can work. She said that in her time it was quite difficult because when you just go inside the law, you may not know where to start. Plus there is that fear of moving forward, which was quite an interesting discussion point at the conference, but that's not today's discussion. She also said that get templates from mature competition agencies in Africa and abroad, scan the environment and see how you can domesticate them. In other words, do not reinvent the wheel. She also said we need to lobby, we need networks. So ask for opportunities where you can speak to create awareness. And she said that establish cooperation frameworks that deliver real value. The mature authorities have a lot to share with new authorities. So yes, needless to say, we are extremely delighted to host Stellah, Denis and Vincent today. It's been a significant road and a significant development to have the merger regime up and running in any event, to have it operational by the 1st of November. So we are welcoming the 3 officials of the EACCA. The first is Ms. Stellah Onyancha. And Stellah is the acting registrar of the EACCA. She's also the deputy registrar in charge of Monopolies and Cartels Directorate. And she held that position for 3 years already. And prior to joining the EACCA, Stellah was the manager of enforcement and exemptions at the COMESA Competition Commission. And before joining COMESA, Stellah worked for the Competition Authority of Kenya in various capacities, including as manager of mergers and acquisitions. And last position was Director for Competition and Consumer Protection. So Stellah has over 20 years of experience in competition law enforcement. Stellah holds a master's in economic policy management from the University of Ghana, a BA Honours in Economics and Business Studies from Kenyatta University, and various certificates in competition law and policy, strategic leadership, senior management, and corporate governance. And Stellah enjoys spending time with friends and family and gardening. Right, Vincent. Vincent is the Deputy Registrar. He is tasked with mergers and acquisitions at the EACCA, and he has been in this position since June of 2023. He is an economist with professional experience in private equity and impact investing, particularly entrepreneurial ecosystem building and entrepreneurial industrialization in emerging markets. He spent much of his career thus far at the EAC, the German Institution of Cooperation, Oxfam, and the University of Rwanda. At the EACCA, Vincent is responsible for the evaluation of cross-border mergers or concentrations, and to consider whether those are appropriate from a competition law perspective. Vincent holds an MBA from the Colorado State University, as well as a MSc in Agricultural Economics from the Makerere University in Uganda. Vincent is a nature enthusiast. He treasures any moment that he can spend in the countryside. And then Denis Kabbale. Denis is a competition at the EACCA, and he's joined the EAC in 2017 already. He previously worked at the Directorate of Trade at the EAC Secretariat for 3 years, and before that at the Inspectorate of Government for 6 years, and before that he worked at a private law firm. And Denis holds a Master of Laws in International Trade, Business and Investment Law from the University of the Western Cape, a Bachelor of Laws at the Makerere University in Uganda, postgraduate diploma in legal practice as part of a bar course, and various courses in competition law and policies. And his interests are sightseeing and playing cricket. It is lovely to have you here. Stellah, we are going to start with you. If you can inform us of this institutional and legal framework of the EACCA, and from there on we will move to Denis and then to Vincent. Thanks very much and welcome at this webinar.
Thank you very much, Odi, for that wonderful introduction about EACCA and for introducing us. Thank you very much for even mobilizing our stakeholders for this very important session to interact with them.
Absolutely.
Stakeholders, thank you very much. I just want to take you through our legal and institutional framework. Then from there, quickly about our functions, what we have done so far as EACCA, our priorities, and then I'll hand over to Denis to proceed in regard to mergers. So we'll proceed as such. Thank you very much. In terms of the outline, so as I said, we are going to quickly take you to the regulatory and institutional framework, the functions of EACCA, then what we have done as an institution in terms of regional enforcement and also other developments, then our priorities going forward. Then Denis will pick up, and also I know most of you are here today to hear about mergers, and Vincent will take us through that. So in terms of our introduction, so far, EACCA is an institution of EAC, and as you all know, the EAC is a regional intergovernmental organization which has 8 partner states, that is Democratic Republic of Congo, Republic of Burundi, Republic of Kenya, Republic of Rwanda, Republic of Somalia, the Republic of South Sudan, Republic of Uganda, and the United Republic of Tanzania. Of course, the mission of EAC is to widen and deepen economic, political, and socio-cultural integration in order to improve the quality of life of the people of East Africa. And this is through increased competitiveness value-added production and investments. So in terms of the population, EAC has a total population of over 300 million people, and it covers a total surface area of 4.8 million square kilometers. In terms of its gross domestic product, EAC stands at US dollars 338 billion. So that is just in brief about EAC. If I go straight away to introduction, we work the treaty for the establishment of the East African Community provides for the establishment of institutions, and that's why we were established as an institution of EAC. Under that same treaty, Article 75 provides for competition principles. The treaty has recognized that competition is very critical, and that's why the Council of Ministers adopted the East African Competition Policy at its meeting, which was held in 2004, and then the EAC Competition Act was enacted in 2006. So that is the history I wanted at least the stakeholders to know. Then from that treaty, the summit directed that this has to be anchored in the EAC Customs Protocol as well as the Common Market Protocol. So the two protocols for the EAC, they provide for competition, and they clearly state that partner states shall prohibit any practice that adversely affect free trade. And also this is including agreements, understanding, concerted practices, which has the objective or the effect of prevention, restriction, or distortion of competition within the community. Article 33 of the Common Market Protocol, the EAC Common Market Protocol, goes further and reiterates the same and goes further to provide for consumer protection as well as other aspects of concentration, even partner state subsidies. So it kind of explains the same, and in addition provides for consumer protection, which is also key and which is also anchored in the Act. So if we can, that is about the legal framework and how we started. And that's why now we came up with the EAC Competition Act. The EAC Competition Act was enacted. Denis, can you please move to the next? So in the EAC Competition Act, it also provides for the EAC Competition Authority, the establishment. So the EAC Competition Authority is anchored in both the treaty, which provided for the establishment, and also the Act. And as I said, the Act came into force in 2014, December. And you've talked about the amendment. I think Denis is going to talk about it more. He's going to expound about it more. And this one was gazetted in December last year. It was assented in 2023 and gazetted in last year, 2024. So moving from our regulatory framework, basically the mandate of the to promote and protect fair competition, and also to enhance the welfare of the consumers within the community. So in terms of jurisdiction, EAC has an expansive jurisdiction, and it provides for all those matters which are cross-border effect. So as long as a matter affects more than 2 partner states of EAC, then that's a matter we handle. So the Act provides for the salient features of a modern competition law. It provides for restraints by enterprises, what many people know as anti-competitive practices or concerted practices and agreements. It also provides for abuse of market dominance. It provides for mergers as well as partner states, subsidies, public procurement, and consumer protection. I may not go into details about the restraints by enterprises, but the Act prohibits some of the key prohibitions which are mentioned under the Act is collusion to fix prices, allocation of markets, allocation of customers, restraints on trade regarding the output. So the Act is clear on what is restricted, what's prohibited under the Act. In terms of the abuse of market dominance, the Act provides for both exclusionary and exploitative conduct. So it's clear, and it borrows from modern best practices. In terms of mergers, I think my colleague Vincent is going to dwell more about it, so I don't have to expound, but it's clear. And the amended Act mainly dwelt on mergers. It amended areas where there was some serious lacunas in mergers, so they are going to expound on that. It provides for partner states subsidies, consumer protection. It also provides that consumers should be protected from false representation and questionable conduct in consumer transactions, and also substandard goods and unsafe goods, among others. So the Act provides for that. When we go to, we'll move from there now and go to institutional framework. In terms of the institutional framework, the authority is comprised of commissioners, and commissioners are nominated by the partner states. Each of the commissioners must be nominated by the partner state. It's anchored in law, and then they are appointed by the Council of Ministers. That's what happens, and their main role is to provide policy guidance and also make determination on cases that are being investigated by the Secretariat or the authority. In terms of the Secretariat, we are the Secretariat. The Secretariat is headed by the Registrar, and also the work of the Registrar is to be responsible for the day-to-day management of the affairs of the authority. So both the Registrar and the staff, they are appointed by the Council of Ministers. So that is what happens. So the Council of Ministers, they nominate from their countries people who conduct the interviews, and then they're appointed. So that's what happens. In terms of how we work, if there is a matter that has been, if there's some stakeholder is not satisfied by the decision of the authority, they have a recourse to appeal to the East African Court of Justice, and they are the ones who review the decisions. They receive appeals from the authority. So the authority also reports to other policy organs of EAC. We have various policy organs, such as the East African Legislative Assembly, the Sectoral Council for Investment, Finance, among others, trade and finance, among others. So we report to other policy organs. When we continue with how we operate, the functions, our key functions are anchored in the Act under Section 42 of the Act. And some of the key functions which we deal with is investigation and compelling evidence. We gather information, we hold hearings, we issue legally binding decisions, we impose actions and remedies. So that's clearly anchored in the Act. We also conduct consultations with stakeholders. We do other matters. We engage in market inquiries and conduct market research and market inquiries. Denis, please move to the next slide. We also refer matters to court for adjudication that is provided for under the Act. we developing of appropriate procedures and sensitization tools that's provided for under the Act. The Act also empowers us to cooperate with regional and international organizations on competition matters. So in terms of what we have done so far as EACCA started by developing the first strategic plan, and the first strategic plan was mainly on institutional setup. We put the requisite infrastructures in place. That's when the first commissioners were appointed, and then they started proposals for amendment to the Act because there was realization that there were lacunas, as Madam Mukoroni explained to you during the last presentation, and that's what happened. Then we developed and adopted prioritization framework. This is key because of the scarce resources within the community like any other organization, resources are scarce. So we had to prioritize on which cases and which sectors to conduct inquiries or to undertake investigations. So this is what governs us when we select sectors. And then that prioritization framework is anchored in the EAC policy documents. We have the EAC development strategy, we have the EAC Vision 2050, and also among other policy documents, which we anchor our prioritization framework in and guides us on how to prioritize on cases, on market inquiries, among other things. Then we also developed an outreach and advocacy strategy. This also is critical because it enables us to select the target audience and communicate. The message we communicate normally through our sensitization is what the Act provides for and how we intend to collaborate with our stakeholders and then their need for compliance. So this one has been also a guiding tool for us when we are conducting our sensitization initiatives and awareness creation initiatives. Then we've put the right infrastructures in place, office, equipment, recruitment of key staff. As you can see, the three of us were recruited, and this is a milestone, we can say. Then we have developed various instruments. The regulations have been developed, guidelines, procedures, guidelines, and then we are ready to go in implementation or enforcement of the Act. In terms of, again, what we have done, we've done technical assistance and capacity building initiatives in partner states. You know, EAC, the way it's structured, we work closely. Partner states have an obligation to support EAC in the implementation of the Act. And that is anchored in the law. And what we have done, because of the different terrains within EAC, some authorities are developed, some are starting. So we have tried to conduct technical assistance and capacity building to enable those authorities who have not developed to at least to develop, to come up with laws. And we have seen some milestones, like Uganda, now they have a national law. Burundi, they have commenced the implementation of their law, the competition law. Rwanda, Tanzania, and Kenya, they are on, even DRC, they are also young agencies which are coming up. So we are also moving on to conduct the same in South Sudan, who are having a competition bill, and also Somalia, who are starting. So that's what we are doing. Those are the initiatives we are doing. Then we've conducted multi-stakeholder sensitization a lot to promote competition culture within the community and also enhance or promote compliance. What we have done again is we have commenced implementation of the Act in other provisions of the Act, specifically restraints by enterprises and consumer protection. We've handled consumer complaints. We've also received complaints relating to anti-competitive practices, and we've handled them. And also, for us to be able to engage in investigations, we've commenced with market screening in sectors which we think markets are not working well, and they may be portraying some anti-competitive practices. So currently, we are doing the fertilizer and steel sector. In terms of, again, what we have done regionally, we have negotiated and signed MOUs. Denis will talk about the MOU between us and COMESA, but we have also done it with the partner states, bilateral MOUs. And what we have done is we are working closely with the partner states. We are having a cooperation framework with the partner states because that is what the Act envisages. In terms of participation in the regional and continental forums, here I'm mentioning about the TFTA and African Continental Free Trade Area, especially in terms of the competition protocol. Yes, we have participated greatly in that. We have provided positions together with the partner states and state parties. So that is, we have mobilized the partner states so that we can have one position when we go for negotiations. And as you are aware, the EAC competition protocol is in place. I think that is all about the initiatives. If I can quickly go to our priorities, we continue with implementation. We have developed our second strategic plan for the authority, and we are intending to operationalize the matcha regime in November. You've seen the notice. Vincent is going to elaborate more. This is our low-hanging fruits. And also, we are continuing with both soft and hard enforcement, as well as advocacy and market screening, because it's through market screening that's when we'll be able to obtain some information on the markets that are not working well. And some matters have been investigated by other jurisdictions, and also we'll be able to do that because they have cross-border aspect in them. What we will do also, we'll continue to increase our efficiency and effectiveness. We want to automate our processes so that it's easier and not burdensome for our stakeholders. We'll also be reviewing what is in place already, the guidelines, regulations. If there's need for amendment, even the Act, then we'll be able to do that. So far, that is our priorities, and we intend to recruit more staff. Currently, we are working on recruitment of more staff. I hope it's our prayer that it's going to happen before the end of the year. Like now, we are reviewing the JDs in job description in readiness for recruitment. That's what is happening currently. And the ministers, the Council of Ministers is likely to meet as from the week of September to give a go-ahead so that recruitment can happen, because we want to start enforcing the regime with a number of staff who can be able to assist. I think that is so far what we have done, and that is our priorities ahead. Of course, deepening capacity of our stakeholders, sensitization will be continuous because we need them to deepen that culture of competition and then promote compliance. Then, of course, we'll try to continue implementing our outreach and advocacy strategy initiatives. Then, of course, we will urge, for us, what we do, we urge the partner states and we support where we can. Those who have not developed, I mentioned about the South Sudan and the Federal Republic of Somalia. So we'll urge for them to fast track having the national laws in place. It will be easier when they have the national competition laws for us to be able to implement the regional competition law. Of course, we'll deepen our collaboration with the national, regional, and also international organizations. And also, resources are scarce. So we will try to mobilize resources so that we are able to progress with our work without much difficulties. So those are our priorities. I'll just hand over to Denis to proceed highlighting in regard to the amendments. Thank you.
Thank you very much, Stellah, and thank you to our listeners and audience. I'm going to make a brief presentation, basically to highlight the amendments which were made in the Act. And most of the amendments, like it has been mentioned, were on Part 4 of the Act, and Part 4 deals with mergers. It's also important to note that the Act was enacted in 2006, but it came into force almost 8 or so years later. So it was realized that there was a number of years in between. So we did a review and an assessment of the merger regime by undertaking a study, and it notified us that there were so many gaps so that we couldn't enforce the Act as it was, and the gaps couldn't be addressed in subsidiary instruments like regulations or guidelines. That's what prompted the amendments. So I'll begin speaking about the amendments, and first in Section 11 of the Act. Section 11 talks about notification of mergers. So initially, the Act didn't prescribe for thresholds, but like you can see on the presentation, in Section 11, subsection 1, we have introduced an aspect that undertakings intending to execute a merger that are within the thresholds prescribed by the Council in Section 11, subsection 4, have to notify the authority. So why did we need to provide for thresholds? One is that we needed to give sufficient scale on which transactions have to be notified at the regional level. The second aspect is that we needed to capture on the transactions that have of a regional nature. But it also helps us to exclude mergers which are benign. Those are smaller mergers. And also, fourthly, it makes a distinction between what the authority will handle and which transactions will be left to be handled by the national competition agencies. So that was important. The next issue in Section 11, the new amendment, is you look at Section 11, subsection 2. There wasn't clarity on when that notification had to be made. So in the amendment, there is a provision that the notification shall be made upon conclusion of the agreement in respect to the merger. And secondly, that notification has to be done by the undertaking acquiring control through the merger. So that also helped in providing clarity in when it comes to notifications. So on the next set of amendments is there in Section 12. In Section 12, subsection 1, it gives the criteria that the authority will take into account in approving mergers. Initially, the test was that the merger had to create and strengthen a dominant position, thereby strengthening, substantially lessening competition. So in the new amendment, the test is only on substantial lessening of competition that will be applied in merger assessment by the authority. That was also quite important in to make sure that there is clarity on what is going to be, what the assessment is going to be based on. In Section 13, subsection 2, there was initially the period which was granted to the authority was only 45 days. So this, we felt that the period was a bit short. So it was important to increase the number of days for sufficient time to review mergers properly. So the number of days have been increased from 45 to 120. Then in Section 13A, this was a provision which was in the regulations. That's the power for the authority to revoke mergers. So it was felt that it was a substantive provision of the law, which should not have been left in the regulations, which is a subsidiary instrument, but it needed to be in the Act. So that was more of shifting that provision to the Act. The other amendment is Section 37, subsection 2. And this has given the authority corporate personality. This was important for two reasons. Given the powers that the authority has, it was important for it to be given that corporate personality so that it can undertake most of the tasks. For example, to sue and to be sued, and also to do all the things that a body corporate can do. But it's also in line with other EAC institutions to be have that corporate personality. The next one is Section 42, subsection 3, and this is on fining fees. Initially, we had fees that were provided for in the regulations of 2010, but also this was also realized that it was important to have the substantive power to prescribe fees in the Act. So this is also anchoring that substantive provision where it needs to be. The next provision is on Section 42, 42A1, whereby the authority was given powers to impose financial penalties not exceeding 10% of the undertaking's annual turnover within the community for the preceding financial year. This is a new provision. We didn't have it before in our instrument. In terms of also what has been done, the authority has developed and gazetted the merger thresholds, which provides that for transactions which will be notified to the authority should have a combined turnover or assets in the community of the merging undertakings, whichever is higher or equals to or exceeds $35 million, and at least two of the undertakings to the merger have a combined turnover or assets of 20 million. In the community. There is an exception to this unless where you have the parties to the merger achieves at least 2/3 of the aggregate turnover or assets in the community within one and the same partner state. So this is an exception to the thresholds whereby transactions affect a given partner state more. In terms of fees, we have developed fees which have also been gazetted that are payable by undertakings. So for aggregate value or assets, aggregate value of assets or turnover, whichever is high of the parties to the intended merger acquisition, whereby the transaction falls between $35 million to 50 million. The fee payable is $45,000. Where you have a transaction of $50 million to 100 million, the fee payable is $70,000. And for transactions which are above 100 million, the fee payable is $100,000. So in terms of the MOU, I'm going to speak briefly about the MOU. The authority concluded and signed an MOU with the COMESA Competition Commission. And this was after recognition of a number of issues. One is that there is overlapping membership between the 6 partner states of the East African community are also members of the COMESA. So there was need for us between EAC and COMESA to coordinate our activities. So the MOU, we have agreed to share information, especially when it comes to matters of joint investigations. Also, we agreed to address potential duplication in the enforcement so that it helps us to create certainty and predictability for stakeholders. And also we agreed to cooperate and coordinate in carrying out market inquiries and studies and also technical assistance. In what is next when it comes to what are the next steps for us to actualize this relationship between the EAC and COMESA, we did agree that we developed a work program which is an annex to the MOU, and we agreed that we'll have a meeting under that work program. We agreed that we're going to have a meeting, and probably in the month of September. And the purpose of the meeting is that we need to come together to sit and further agree on how we are going to divide and deal with the issues of our respective competencies, in particular on issues which deal with overlapping membership.
Yeah.
After we agree on that, then we need to take our proposals to our policy organs for approval. Why it's important is that we noted that in our respective legislations, we needed to have provisions, especially which provide for referrals, which we don't have right now. So as a way forward, we agreed that let's have negotiations and let's agree on how we can then put the outcome of our negotiations to within a legal framework, which will agree whatever form that the framework will take, but it also provide certainty, because as many of the stakeholders will know, is that the MOU to a given extent is non-binding. I think next it's the Deputy Registrar Majas will take us through the next slides on what are the next steps. Vincent?
Thank you. Thank you very much, Denis, and thank you very much, Odi. It's a pleasure to be here, as I said earlier. And also thank you to everyone else doing the webinar today. As my colleagues have already elaborated, Odi, what the authorities have been going through over the years, the developments of the instruments, including some important amendments to the Act, which Denis just talked about right now, which mostly focused on Part 4 of the Act. We also talked about the challenges that the authorities faced over the years, but some of those challenges actually still remain. For example, staff numbers, we're still struggling with that, but we're hoping that that can be worked on very soon. But we also have we have just developed our new 5-year strategic plan, which should come on board very soon. And the important thing is that the theme of the strategic plan is learning by doing, through coordination, perfecting coordination and collaboration as we work through, as we'll be mostly working with the partner states, as Dr. Ndejes talked about in reference to Section 43 of the Act. So we're also welcoming a new board. So we had a board that served for 2 terms, 4 years each, so 8 years. With very limited enforcement. So all these developments mean that at least I think it's the right time for us to move. So in terms of the intended commencement of the merger regime, so we recently published in the EAC Gazette a notice on commencement of the receipt of notifications. So this was after long consideration, which was actually approved by the board. So the notice itself, I think, which you have seen, which is also can also be found on our website, where we are starting receiving notifications, cross-border notifications, transactions that meet the requirements of the Act, as Denis has explained. So they are cross-border, they meet the thresholds as provided by the Council. All these notices are on the website. So from November 1st this year. So we have that notice on the website as well as most of the important instruments. We're also in the process of putting that notice in the East African newspaper, but also in all the partner states. That should be done sometime before the end of this month or somewhere beginning of next month. So most of the important tools that would support this particular enforcement have been developed over the years. The tools are there. Some of them are in the regulations, and they are all on the website, which you can find. So we're ready to start reviewing those transactions, even with the challenges that we have, because we're really counting on working on perfecting this collaboration with the partner states. Next slide. So in terms of notification itself, I think Denis touched on this. So this is very much elaborated in section 11 of the Act. So the notifications will be addressed to the registrar. So we accept both physical copies and was also provided in the notice an email address where you can actually submit your notification by email. You'll get a notification and an auto response that your notification has been received. But if you submit at the address that is provided, then of course we will receive the notification, stamp it, and then if you provided multiple copies, you go back, we stamp your copy. Again, Denis just talked about this, so the thresholds are there. They can just be on the website. They are generally higher than the thresholds in partner states. So the threshold, the notifications are those that meet the requirements of the Act. That is, the cross-border in line with Section 4.1 of the Act. The thresholds are the ones that have been specified by Council in line with Section 11.4 of the Act, and the resulting change of control. So those are the basics that you should know right now regarding the type of transactions we're talking about. Denis, next slide. So come November 1st, what will happen? What should we expect? So we really encourage at this point. We really encourage that you should. That parties can approach us for just for clarifications in what we call pre-notification meetings. So we can have these meetings can be physical or virtual. And we discuss the process, we take the parties through the process, and also just for us to have an idea of what the transaction looks like, what it's about, what's the nature of the transaction, which partners, what are the partners that are affected, what's the estimated turnover, and which are the companies involved, what's just getting a brief idea of what the market is, or what the parties deal in. So just this pre-notification meeting, we think will really be important, because as you know, we're just doing this. It's a new regime. We have new tools. So just to get through this, getting the forms, by the way, and all the tools can be found. The required forms can be found on the merger regulations, which are also on the website. But just to go through that, trying to understand how to fill in those forms, that really we really encourage that. So that's really what we think at this point. What we'll do. One thing I want to mention, which is important, which Denis mentioned there about so we shall this month we are embarking on going to partner states again to try to do this sensitization. I think Stellah also talked about this sensitization on especially the commencement of the merger regime, but also eventually when we sit down with COMESA and we come up with this agreement, this framework we're talking about, we also then have to go and do the same. Again, we'll let you know, we'll let the parties know if we came up with that agreement and how it's going to work. So really between now and November 1st, we're really focusing a lot on those preparatory stages, bringing the sensitization, creating awareness, and just clarifying a few things. But at that time when we start, if you have to, if you are considering, you have a transaction coming up, we really encourage you to reach out to us, and then we can have a discussion and see to give you, we guide you and see what if you need to notify us or not. I think that's it, Odi.
Oh, yeah. Thank you very much, Vincent and Denis and Stellah. It's been such a great explanation of what is the current status and what we can expect going forward. Thank you so much for that. I have a couple of questions, but I think let's first address the questions by the audience, and I'm going to start chronologically in the way that they came in. The first one is from Joshua. What is the EACCA's approach towards restrictions on trade across the EAC member states? And if I can possibly add to that, just to contextualize it a little bit, you spoke about potential anti-competitive effects that you have come across and investigated at this point. Have there also been complaints in relation to restriction of trade? And if not, is there kind of a conceptual framework in relation to how to deal with that, as opposed to the more familiar restriction of competition framework? Stellah, if you could possibly help us with that one.
Thank you, Odi, and thank you, Joshua, for that question. The approach of EACCA towards restriction of trade across EAC member states. So many times our stakeholders or people confuse between a non-tariff barrier and a restriction on competition. Those two are more or less related. At times, non-tariff barriers, they come as non-tariff barriers, but in real sense, they are restriction to competition, because we address competition so that trade and regional integration may be enhanced. In terms of this, is that if there's a restriction on trade, then our approach will be to, because we work closely also with, we have departments under EAC Secretariat, the Customs and Trade Secretariat Directorate, which is in charge of trade as well as customs. So we work closely. Anytime we receive a matter relating to that, we have to work closely with that directorate to get to know how far they are. So many a times what is being addressed is the non-tariff barriers, but also we've engaged them anytime they're having a meeting with stakeholders with regard to trade. We'll be able to join that meeting so that we sensitize the stakeholders in terms of how they can complain, because what we can do if we receive complaints, because if we receive complaints on restrictions to trade, and those complaints, they also lead to restricting competition and distorting competition, which affects trade in the end run. So we need to address, so we work closely with the Secretariat in trying to address this. And also, if the act is, if there's a matter touching the EAC Competition Act, because that is our mandate to protect and promote competition, in terms of, once we promote and protect competition, that means trade is enhanced and people are able to trade freely within the region, as well as regional integration is deepened. So that aspect we work closely, and what we can do as an institution of EAC is also to provide our opinion in terms of the negative effect of restricting trade within the region, because without trade, then regional integration can be affected. So providing advisory opinions and solicited advice to the community on the effect of that. So that's what we can do for now. Otherwise, we'll be able to handle that, such kind of matters once we receive, and then we can also, what we do also, we go around the partner states through the department, that trade section, which also inquires what is happening, where restrictions are happening. And if you've been watching closely lately, there was a press release by the Secretary General in terms of how trade is affected in the region, and Of course, our approach is we have to do it diplomatically to ensure all of us are on course. So for now, that's how I can respond, Odi, and to Joshua.
Yes.
Thank you very much.
Thank you very much, Stellah. And this is perhaps also something that we can make the business councils across the EAC aware of, that they can approach you with anything like that. Thank you for that. Then just a question from Nazira at Bowmans. Is the merger review period of 120 days calculated on the basis of calendar days or business days? I think that is a question to Vincent based on our allocation of tasks.
Yeah, thank you very much, Nazara, for that question. Is work days. So it is work days. So it doesn't include. It doesn't include. Yeah.
Right. Thank you very much, Vincent. Then Diodone, she asks, is the EACCA going to be a one-stop shop in that mergers notified to the EACCA will not have to be notified to national competition authorities within individual partner states? Denis, maybe you can assist with this one.
Thank you very much for the question. I think that's the intention. If you look at Section 4 of the EAC Competition Act, it's supposed to be a one-stop center for merger notification. But it's also important, especially to our listeners, to know that the EAC region is quite integrated. It's one of the most integrated regions.
It is.
And that's one of the importance why we need to start this merger regime to basically complement what has been agreed on by the partner states in terms of their integration agenda. So, but there would be some exceptions to the rule. One is whereby you could have transactions which don't meet the thresholds that we have set, but also you could have transactions which affect a given partner state more, 2/3 of the turnover or assets in a given partner state. That's also an exclusion. But as a general principle, we are meant to be a one-stop center for notifications. Thank you.
Thank you, Denis. And that will amount to some degree of savings. According to our records, I think there are 5 authorities in the EAC that's already operational. If that is correct, right? Kenya, Tanzania, Uganda, Burundi, and Rwanda. So that will definitely constitute a saving, and probably one of the reasons also why this authority will be so valuable from an efficiency perspective. Right. Then let me just make sure I do not miss anything, because we have new questions. Right. Then what happens if transactions close before 1 November? I guess one would be off the hook at the EACA, but anyone, Vincent, maybe can you give us some guidance there?
Yes, a simple one. Yes, actually, that is also on the notice. If you read the notice, that is very clear. Before November, just proceed the way it is. We are really we're opening shop November 1st, going forward. Yeah.
Right.
Just to clarify further, also in addition to what Vincent has said. So if a matter is being handled, and that is also in the notice, if a matter is being handled by a national authority, they'll continue and finalize that matter, even if 1st November approaches, because they had already commenced the process. Thank you.
Right. And then what is the remedy for parties that would not be content with a decision of the EACCA on a particular merger?
Okay, I mentioned about the remedy. If parties are not contented by the decision of the authority, they have a right to appeal to the East African Court of Justice. That is like our tribunal. We have East African Court of Justice, so they can appeal there if they are not contented with the decision of the authority.
Right.
Thank you.
Thank you, Stellah. Then do the parties have to wait until the transaction has been approved, or may they proceed with implementation immediately after the notification? Stellah?
On our side, the law is very clear. It's a suspensory regime, so they have to wait until they get approval for them to implement that matter. That's what the Act says and the regulations.
Right. Yes,
That is done.
yes, right. Someone asks, the authority's website states that mergers with a cross-border effect are those where both the acquiring firm and the target firm, or either the acquiring firm or target firm, operate in two or more partner states. So what would happen where the transaction is notifiable to both COMESA and the EAC? I guess this will be the subject of your September meeting. We will get feedback on that particular issue after your meeting with COMESA. But is there anyone, Denis?
Thank you very much. And I think as a reassurance to stakeholders, this is a matter that has been raised over time. We are alive to that fact, and we have put a lot of efforts towards addressing that issue, specifically of overlapping membership. So we have been in touch already after signing the MOU with the COMESA Competition Commission. We have notified them of our readiness to meet again so that we discuss our different perspectives on how to address the issue of overlapping memberships. But we have also gone ahead as an authority to develop what we believe is our proposal on how to deal with that issue. So after we are done with negotiations with COMESA, then the next step will be anchoring it in law. So on our side also, the Office of the Counsel to the Community has been participating in this, and we are ready to give it legal effect. And I also believe once we give it legal effect, then everyone will be comfortable with the outcome. So yes, it's something that we are really dedicated to resolving.
I see. And Denis, are there vastly different views in terms of handling the issue of duplications, whether it relates to let's say, the sharing of notification fees or other aspects, for example, who has jurisdiction between the EAC and COMESA? Is this a point of big disparity at the moment, or are you nearly there, just conceptually?
Thank you, Odi, for that question. My take, and because I've been happy to interact with the team from the COMESA Competition Commission when we negotiated the MOU. There is willingness on the leadership of COMESA Competition Commission and the leadership of the East African Community Competition Authority. So I don't think there is a large margin of divergency. And I believe we'll reach a fruitful conclusion on how to address the issue. Because I think the areas of, but we also appreciate the fact that it's important for both agencies to address it. So that's why there is a good degree of understanding on how to proceed with the issue.
I see. And Denis, let's say just hypothetically that there is not agreement on the way to go forward on this. Is there a possibility that the 1 November deadline may be moved out? Or may we get a situation where we decide let's continue with the 1 November operationalization of the merger regime on the basis that there will be initially some duplication of certain fees or certain jurisdictions? How do you foresee that scenario playing out?
That's an excellent question, Odi. I think both options are on the table. Why do I say that? For us, we are Secretariat, and the guidance to begin with receiving and operationalization of the merger regime came from our commissioners. So it would be quite difficult for me to give a position one way or the other. So we expect to have a commissioners meeting probably in the coming weeks. So, but we also, it would be good to go back to the commissioners after we have negotiated with, had a meeting with COMESA, so that we take back the feedback as opposed to having that before, so that we have some clarity on how to proceed. But it would be difficult to commit what the the board the direction they will give.
Yeah, right. Thank you very much, Denis. Someone asks, when will the EACCA be fully constituted? As some member states are yet to nominate commissioners. Stellah, maybe you can assist with that one.
Thank you, Odi. Thank you very much for that question. Maybe in addition to what Denis said, I think we were clear that we are ready to start the merger regime in November. And initially, ideally, when this takes place, there are some teething challenges which may come across. And what we intend to do is to start, even as we address teething challenges. We are committed to addressing the challenges, both ourselves and COMESA, but we are commencing the merger regime in November as per the directives. And given that we have been in place for quite some time, remember you mentioned about we started in 2014. So up to now, we have not implemented some provisions of the Act. This is the right time to implement as we address. We are ready and we'll address that. We are committed, but we'll start as we address. It will have not addressed them by then, but we believe and trust that we'll be addressing them before commencement because we have 2 or so months to do that. So in terms of the commissioner's appointment, the commissioners, that is, remember I said they have to be nominated by the partner states. So far, we have received some nominations. We also did send some letters reminding the other partner states, and so far there is some progress. So we are hoping by November, all the commissioners will be on board and they will be appointed because that's when the council meets to appoint. So that will be done by November. That is how I can respond to that. Thank you.
Thank you, Stellah. How often do the council meet?
The council, they can meet as and when a matter requires them to meet. There is extraordinary, and there is the council meeting, which is normally in November. But in between, they can meet. Remember, I mentioned they are meeting early August because of some matters which cannot wait up to November. So they meet for extraordinary to discuss about certain matters which needs of urgency at times. So they also meet in November for the council meetings, which is as per the calendar.
Correct. Thank you, Stellah. That's very helpful to know. That's very reassuring. Right, another question. The notice states that mergers that have already been filed with national authorities will not be notifiable. But, and this is an interesting twist to the previous question, what about transactions that will be concluded before November 1 but have not yet been notified to national authorities? I think you may be in trouble there. Vincent, is there something that you'd like to assist us with?
Maybe could you just maybe I didn't get the question properly.
Right. The notice states that mergers that have already been filed with national authorities will not be notifiable come 1 November. But what about transactions that will be concluded before November 1 but have not yet been notified to the national authorities? So that may include any one of the 5 that we have mentioned. Probably Kenya and Tanzania as the big guns.
What I can say is if the transaction meets the requirements of the Act, and has not yet been notified to the NCAs by that time, but meets the requirements of the Act, I think they should notify.
The EACCA?
Yes, if they meet the requirements of the Act. So this is exactly what I was talking about, the pre-notification meetings. We really emphasize we should, if people are not, if someone is not clear, they should really just give us a call and we talk about this and then we clarify.
Yes.
I don't know whether Stellah can add anything on that, yes.
So, Odi, ideally, if before the notice, our notice is clear, it's 1st November. That's when it comes into effect. So if a merger took place and they did not notify the national competition authorities that they were supposed to notify, then that is a matter implemented without authorization by that national authority. So what they can do is that to investigate and penalize, and then we come in also if it does that cross border. So that is an anti-competitive merger.
Exactly.
So that's how we can come in that respect.
That's right. That's right, yes. So maybe the short answer is you may be interested in notifying the national authorities. never conclude a merger before there's been a notification. Thank you for that question. Then another question is that I understand a transaction would constitute a notifiable merger subject to applicable thresholds if it involves an acquisition of a controlling interest. How will this be assessed by the EACCA? Right. Maybe Vincent, if you want to go for this one.
So we have guidelines. We have the merger guidelines. I think they are not on the website yet. They are not yet. They haven't yet put those. But the guidelines elaborate how we will go about defining this control issue. Control is a very big part of the notification. Yeah. That's section 2 of the Act. So it's the guidelines, and there are several layers of this. I don't know that Stellah is more familiar with these guidelines. But then when we finalize the guidelines, you upload. But then maybe Stellah, you want to elaborate on this, how the guidelines will. But control, control is a big part of defining the transactions that meet the requirements of the Act. Yeah. Stellah, do you have any more information?
Very much, Odi, for that question, and the audience who asked that question. The aspect of control is clearly defined and elaborated under the Act and the regulations. Maybe we can share what it means by control, because it talks about 50+1, then material influence. So it has many aspects. So we'll consider all that depending on the matter, and it will be done on a case-by-case basis. That's when we be able now to establish control. That matter, when we are doing the assessment, does it lead to control? Because if it doesn't lead to control, that is a point where we can tell the parties this matter, as long as it meets these aspects, the merger thresholds, and it's a cross-border, it has a cross-border dimension, but the control, it doesn't lead to, because control is what now enables us to do the assessment, the merger assessment, and then conclude that this merger is going to lead to substantially lessen competition in the relevant market. So control is key, and we have various parameters under which we look at that aspect. So a controlling aspect is clearly defined under the amendments and also the regulations. Thank you.
Right, thank you very much, Stellah. Thala from Stellenbosch University. Can Ms. Onyancha expand on the low-hanging fruit the EAC will pursue as part of the operationalization of the merger regime? And also, was there any international authority or organization that helped with the amendments, such as UNCTAD or COMESA or OECD, World Bank?
Thank you very much for that question. In terms of the low-hanging fruit, I was saying, why we call matters a low-hanging fruit is that parties, they want to invest. So they come to us quickly. They are not like anti-competitive business practices. So mergers are quick because the parties are interested in finalizing the transaction and continuing with their investments. So they are quick and they have timelines. So that's why I mentioned about them being a low-hanging fruit, because we'll be able to deal with them. Any any authority, any competition authority starting, most of them, they start with merger notifications, because of the reason that we are able to handle them quickly, fast tracking, as well as finalize within the stipulated timelines, hence promoting investments. And this can even create more feasibility for the authority. So that's what I mentioned about them being a low-hanging fruit. And of course, because anti-competitive practices, they take quite some time. They take a long period of time to investigate. They can take even cartels. They can take even 5 years to finalize. But mergers, they are time-bound. That is why I talked about them being a low-hanging fruit for us as we start. In terms of the review of the law, the EAC has strict procedures to follow. So what happens when the proposals are made, they are done. So they go through various stages for them to be able to pass. It's a rigorous process which they go through, starting from the partner states, experts, then they pass through the commissioners, they pass through the various sectoral council for legal and judicial affairs. Once they are done with that, then they have also to be discussed by EALA, the East African Legislative Assembly. So it's quite a lengthy process. And once they are done, the summit, the partner states presidents, they are the ones who assent to the bills, to the laws. So it's a rigorous process which goes through the partner states. So that's how EAC is structured. Whenever we want to seek for advice, we could approach bilaterally those organizations for their input on the amendments, so that they can enrich the document, so that when we are passing it over to the relevant policy organs, then it's also enriched. So that's how I can respond. And that was done. We approached some of the key stakeholders, which we thought were important for us to improve on the act. Thank you very much.
Thank you very much, Stellah. A question by Ashley. She asks basically whether there can be a change of control when there's a joint venture that will be part of a merger. And so maybe for me to make it simple for purposes of this discussion, could we expect that the EACCA will adopt basically best practices in terms of the control question? So if there's another document at this point to which you can refer us, just that would give some kind of a reflection of your approach towards a change of control, which may include JVs in certain instances, or maybe not in other instances. Is there such a document that you can say, this is plus minus what we would, until further notice, this is plus minus what we would do? Sorry, Denis.
Probably two or three issues I would raise. One is that we'll have to look at it first on a case-by-case basis, so that we apply the facts to what is defined, because the definition of control is a new input in the Act. That's one. Two, we'll have to go back and also to look at our guidelines. We developed mergers on merger assessment guidelines. So we'll probably just give us some time. We go back, look at what we have proposed on how we're going to deal with the issues on control under the guidelines. Then we'll be in position to give clear guidance to stakeholders on how the authority will be looking at control.
Okay, maybe Odi, what I can respond, I think when you look at the various instruments which we'll share maybe with the participant on how we have looked at the aspect of control in terms of the guidelines, it has been clearly elaborated, and part of what we'll be looking at is joint ventures, and that is will be over 10 years and over. it has to be 10 years and over. So that has been clearly been elaborated under the EAC guidelines. I think we'll
Excellent.
be able to share the guidelines with yourselves, with the participants, so that they can be able to know more how we will assess. But the quick answer I can provide is that we also be looking at joint ventures for those which go for a long duration of time, over 10 years. So that is clearly stated in the guidelines. Thank you.
Right. Thank you, Stellah. There's also a question regarding the issuing of comfort letters. I think in the initial years of the COMESA Competition Commission, I'm not sure whether this is still the practice, but the COMESA Commission would provide a comfort letter stating this merger does not constitute a notifiable merger. And then they would basically make it available. Or I'm not sure whether there are other variants of comfort letters that have started to become normal practice. But what would be the EAC's position on the issuing of comfort letters? Vincent?
Yes, thank you, Odi. So the law does not explicitly talk about comfort letters, but we in practice have discussed this, and we will be doing that. Yeah.
Okay, I'm impressed. I see.
So ideally, what we'll do, Odi, and what we'll do once we receive a matcher, we conduct the assessment, and we realize the matcher is not a notifiable matcher. Of course, we have to write and inform the parties that the law does not apply. It's not a notifiable matcher. It doesn't meet the thresholds. So we'll be communicating. So I think some jurisdictions call them comfort letters.
Yeah.
So, but we have that in mind. That will happen because we have to communicate for the stakeholders to know our analysis, what we have done with their application.
Right. Thank you very much, Stellah. Is our understanding correct that the EACCA accepts the filing of non-binding agreements? I guess that would be in the context of merger notifications. So instead of a final agreement, you have a non-binding agreement? Stellah?
For them to come to us, they have to conclude an agreement. Maybe if you go through the regulations, you'll be clear on that. It's clear. So the non-binding agreement, I'm not sure what you mean by that, Odi, but the Act and the regulations are clear. It's upon conclusion of an agreement. That's when they come to us, when they need to now apply for a merger. So that's what the law states. Thank you.
Probably, Odi, what I can add, that was the position before. There was a bit of ambiguity before the amendment to the Act. But if you look at Section 11, I think subsection 2 of the Act, it's now quite clear that it's upon conclusion of an agreement. So not prior to that.
Okay, right.
Yeah.
Right. Thank you very much, Denis and Stellah. Another question, could we please have some more clarification on the merger threshold exemption, I guess? For example, how might this exemption work in practice? I think there are two, if I remember correctly, Vincent. There is the exemption for in case there's 2/3 of the turnover gets realized in a particular country, and then there's another one, which is what is the other one?
Thank you, Odi. So basically, it is so. I think the second part. I think Denis went through this. The second part of the threshold is that two parties to the transaction must have turnover of at least 20 million within the community. Yeah, within the community. Yes. But unless that turnover is realized within one and the same partner state. So those two parties are realizing the 20 million within the same partnership. That's an exception.
So in that case, we mean that if the two parties generate 2/3 of their turnover in one partner state, then that partner state is right placed to handle that merger.
Yeah. Yeah, that's right. So you would basically take the previous year financial statements and you would go and calculate all the different turnovers. And then you would basically see, okay, of all the turnover in the particular, in the EAC, 2/3 of them are derived from one member state only. So then you know the EAC is not the place for you to file your merger. You'll basically then go to Kenya or any of the other national authorities that have a merger regime in place. What would be the circumstances if a merger takes place where most of the let's say we look at South Sudan and Somalia, and most of the turnover is derived in those areas, but it would trigger the EAC. Well, then you would file at the EAC, but if it does not trigger the EAC threshold, then it would mean that there's a merger notification necessary there, but there's no authorities yet. So then you're basically off the hook, I guess. No need to notify where there's no authority, or is there some kind of a way in which the EAC could through some way or another get that merger under their control, or is that simply not something that's going to happen? Stellah, or anyone?
In that scenario, Odi, what we can do, given that there is an EAC competition law, which looks at cross-border.
Yeah.
This matter is cross-border in nature. So what happens even now, those competition authorities, those countries without competition authorities, they have competent authorities which we work closely with. So we'll be working closely with them. They'll share the information because it has a cross-border dimension, and we'll be able to handle. Because once it's cross-border, we are best placed to handle that matter.
Yeah.
And the framework requires that they be sharing information with us so that we are able to handle that. We are able to do the assessment from the EAC end, because that is a cross-border, if it meets the thresholds of EAC. So if it doesn't, that is now where it can just go like that unnoticed. But what can happen is that maybe now we may need to conduct investigations in future. That is why in my presentation I said we will want to urge the partner states to fast track, so that they are able to also tackle issues. So what happens, and we have witnessed this, is that once also some parties or some companies realize that there's no competition law in place, that's when they anti-competitive practices, for example, thrive in that region, because there is no law in force which can catch up with them. So that's why competition law, EAC competition law, is critical, so that we try to tackle those issues that are happening in those partner states which don't yet have a national law in place. They can be able to work closely with us. And luckily, that is anchored in the treaty and in the act, because the regional law is supreme to the national law. So we can still work on that. That's how I can provide the response.
Yeah, but just on that, Odi, that's an interesting case, because so it doesn't meet the EAC thresholds. And actually, some partners have been talking about this, that perhaps in that case, for example, could we then look at that transaction? The law does not provide for that right now. But also, as the reason, this is why we actually need to practice, to go and implement this merger regime, because as you practice, then some of these things come up. Yeah. So already we are looking at so our this amendment, but also we're looking at perhaps amend the law a bit again. Yeah. There have been some suggestions that perhaps we also should maybe have a provision where we allow where even those transactions that are below the threshold should be notified. That has been a suggestion from some quarters, but we cannot realize that until we actually practice.
Yeah. That's right. And that's also the benefit of getting into the mode, even though everything is not exactly perfect at the moment, due to the benefit of learning by doing. Thank you for that. Will the authority be solely accepting physical copies or online ones? Right. I understand from our discussion that online copies will be accepted. And the question is there an existing online platform? Vincent?
A quick one, not yet. Not yet. That's a very
Okay.
good question. Not yet,
Yeah.
and we're working on that. Yeah.
Okay, right,
Yes.
right. And maybe if that platform does not exist by the 1st of November, can they simply email the notification to the address in the notice?
Absolutely, and will not exist by that time. So they just use
Okay.
the email.
No,
Yeah.
yes, right. Thanks very much. Okay. Then I understand the transaction would constitute a notifiable merger. Okay, that's another question regarding the controlling interest, but that will be set out quite comprehensively in the guidelines, as far as I understand. So the whole issue regarding control is well dealt with in the merger guidelines. Right, let me just quickly check whether some of my questions remain. That one has been answered. That one has been answered. Just making doubly sure. Test. Any priority industries, Stellah? I'm mindful of what you mentioned regarding steel and fertilizer, and from the work that CRED does and Shamba does in that area, it appears as if agri-food is also quite a significant industry. And there appears from discussions or media articles that there will be a focus on digital as well. Are there any other sectors that are standing out that will receive special attention by the EACCA?
Thank you, Odi, for that question. Of course, the sectors that will stand out in terms of prioritization are the sectors which affect the majority of the poor and which are also highlighted in the EAC development strategy as well as the EAC Vision 2050. I mentioned about the agri-food. It's wide. It's a broad. So far, we have started with fertilizer. We'll go to the inputs. We'll go to other inputs of fertilizer and more feeds. Then we'll also look at the other sectors which are critical because the majority of the EAC population, they do agriculture. So our main concentration will be on agriculture, and also the economies of EAC are developing. So we'll be looking at cement sector, among other sectors. So the sectors are clearly highlighted in our strategic plan.
Right.
So there are several sectors we'll be looking at.
Yes.
Because within those period, we'll be able to look at those sectors which we have prioritized and even included in our strategic plan.
Okay, right. Thank you very much for that, Stellah. The way forward in relation to the appointment of a registrar, do you have any idea in terms of process and timing? And are there any functions that's currently hampered by not having an official registrar or not really?
Thank you, Odi. I'll start with the last one.
Right.
There's no function that is being hampered in the authority because my acting position, I was appointed by the Council of Ministers. So there's no function. The functions I'm carrying on the functions of a registrar. So in terms of the processes, I mentioned that the process have commenced. We are currently reviewing the job description, starting from a registrar and other cadres, like the senior analysts will be assisting the other directorates. So that process has commenced by the review. The council is expected to meet in 1st September to give way forward for recruitment. So we hope that process will be finalized soon. Once the council gives a go-ahead, then recruitment will commence. So, so once, and they're the ones, I remember I said the council is the one which appoints both the registrar and the other staff.
That's right.
So that will go on as planned. We'll be able to let you know when it's finalized.
Okay, thank you very much, Stellah. A question from Joshua. Are there any formalities that must accompany a merger filing? For example, legalized copies versus simple copies? Any notarized things that must happen? Or is that something that will still be made clear in the guidelines?
I think the form is very clear. The merger notification form is clear, and the guidelines under it, they're also clear. Of course, we need authenticated documents for us to be able to assess that merger. We need documents which we can rely on. Maybe we'll engage Joshua maybe on that, but we require documents which we can be able to authenticate. Of course, we cannot handle copies which are not signed. If there's a document missing, we require that notarized maybe agreement to say this is what has happened, an affidavit to swear in. So like any other competition authority, the way it does it, that's the same way we'll do it.
Right.
Yes.
That's great. That's great. Following on the issue that that there's no filing platform, is there any way you can indicate the size of documents, or is that something that we must do by learning by doing? Vincent, do you have any figure in terms of megabytes or gigabytes in mind?
Not for just a good question though. Not for now, but I realize why that should be important.
Yeah.
I think let's look at that again, and we will guide on that. Yeah, but I mean, I can see how that can be an issue. Yeah.
Right.
We will work closely with our IT, the Department of IT, to develop those within these 3 months. Of course, we are saying we'll be cleaning our house. What is not in order will be in order by 1st November. Once we commence, I think all that will be in order. So that's the response we can give us of now.
Okay.
Thank you very much.
Thank you, Stellah. And just a general question from my side, and specifically based on the removal of the dominance test in merger context. And that's just a perspective from the work that I'm doing on a daily basis. But it appears from especially, let's say, the SA Competition Commission's approach to large firms or even elsewhere in Africa, that that there's a bias towards small firms, and there's almost, and I don't want to come across too strongly when I say this, but there's almost a feeling that big is bad, even though we don't say that, even though we can never say that, and we will never. But there is some kind of a penalization if we look at the big data cases and so on. So I'm just interested to know how the EAC will deal with that balance between appreciating what bigness brings from a public interest perspective as well, versus appreciating what the smaller guy brings from a public interest perspective.
Odi, what I can say is that we are not penalizing the big firms. Of course, you know that dominance is not bad per se. What we look at is the abuse. So if there's that big firm that is abusing its dominance in the market, then that's where we come in. Otherwise, we encourage firms to innovate and develop.
Yes.
And become dominant. But even as they become dominant, let them not abuse their market dominance.
Yes.
What's happening in EAC is we have small and micro enterprises. The objective of competition law, policy and law in the community is also to promote the welfare of the people, the community, by protecting the market participants, including the small and micro enterprises. So to be able to grow, so you see, if they are abused, they cannot be able to enter the market. They'll be driven away out of business.
Yeah.
So we have to monitor the anti-competitive aspect, the abuse.
Yeah.
Otherwise, we encourage firms to invest, to innovate.
Yeah.
But what we penalize is the abuse of that dominance. So
Yeah.
there's no aspect of penalizing the big firms
Yeah.
vis-a-vis the small firms.
Yes.
It's only, we look at the conduct, the
Right.
anti-competitive practice in them.
Right, right. Thank you very much, Stellah. I think this appears to be our last question, and I've also worked through my list of questions. Thank you so much for staying so long and for letting us exhaust the questions of all of the participants on this call, which was not a few. It is so much appreciated, Stellah and Denis and Vincent. We really appreciate it. And if I can ask our audience, invite these colleagues to your events, whether it's virtual or whether it is in person, so that we can spread the good news. And it means a lot for purposes of the competitive project. If the whole regime can be broadcast as widely as possible to as many audiences as possible. If you need their addresses, I will gladly get their permission to share that with you. I'll gladly share that. So it's so important for us to make sure that this message spreads. And for your wonderful time, colleagues in Arusha, thank you for that. We can't thank you enough. And all the best with this massive process that lies ahead of you. Many of the people in the audience, and I didn't even look at them, their names, they will give you some run for your money, I'm sure. But yeah, eventually I think we all want the same thing. And all the best with that. And if there's anything that Betweenity can assist with, I mean, I will remain in discussion with you on some of the other aspects. But yeah, all the best with a massive task and all the little things that must get into place and all the large and important discussions that lie ahead, especially the two in September and your engagements with the partner states. We wish you all the best with that. Thank you for your great contribution to this continent and for the livelihoods that are present on this continent. We really, really value that and respect that. So on this high note, we will greet you. You must have a lovely evening and yeah, take care on that side and let's stay in contact and let's keep talking.
Thank you very much, Odi, for mobilizing the stakeholders. We are glad to meet again and again. Thank you. Have a pleasure.
Fantastic. Thank you very much, colleagues. Thank you very much. Stay well.
Bye-bye.
Bye-bye.